Hi, my name is Olivia Lee and I'm an associate in the London office at Hunton Kurth. I'm going to discuss some of the data sharing issues that may arise in the context of the current COVID-19 pandemic, specifically the restrictions on data sharing under the General Data Protection Regulation, or GDPR. The GDPR sets out various requirements that must be complied with when disclosing or providing access to personal information to another party. In the context of the pandemic, organisations might need to transfer data quickly, for example, in order to assist with contact tracing efforts. So these are the requirements that should be kept front of mind when doing so. In the first instance, the nature of the data share needs to be established. For example, is the data being shared with another controller, i.e. an entity that's going to be using the data for its own purposes, or is it going to be provided to a processor that's going to be processing data only on the organisation that's transferring's behalf? Or it could be being shared with what's known as a sub-processor if the transferring entity is acting as a processor itself. And if the data is being shared between two controllers, they may be acting as co-controllers or as joint controllers. The requirements that need to be complied with will depend on the nature of this relationship. So, for example, if the data is being shared between co-controllers, where the controllers each use the personal data for their own independent purposes, the GDPR doesn't require the controllers to enter into any agreement relating to the sharing, although in practice many organisations agree on basic contractual provisions in order to regulate their data sharing. For joint controllers, however, where the controllers are jointly determining the purposes and means of processing, the GDPR requires that the parties enter into an arrangement, such as a contract, that determines what their respective obligations are. For example, which party will be responsible for handling data subject rights requests that are received. Where a controller is sharing personal data with a processor, the controller is required to execute specific contractual provisions with that processor, and those are the provisions set out under Article 28 of the GDPR. So in this instance, it would be advisable for controllers to develop a template data processing agreement to be used during the pandemic, which includes the provisions mandated by Article 28. And where health data is involved, this may require additional safeguards, for example, restrictions on the processor's sharing of the data with third parties and the security measures that the processor needs to implement or maintain. Controllers will also want to think about the due diligence that they need to do on processors that they're sharing data with, and making sure that they don't share data with any parties that don't have adequate security measures in place. Organisations also need to consider what their legal basis for sharing is. Even in the context of the pandemic, there has to be a GDPR-compliant legal basis that the organisation can rely on for processing, including sharing, such as consent, legal obligation, or legitimate interests. And organisations that rely on legitimate interests will need to carry out the balancing test that needs to be conducted between their own interests in sharing the data and the likely intrusion on the interests or fundamental rights and freedoms of the data subjects. So the first step would be to identify what the appropriate legal basis for the sharing is, and if that is legitimate interest, carry out that balancing test. And then where health data is involved, as it may be if the sharing is for the purposes of, for example, contact tracing or diagnosis, organisations need to consider the general prohibition on processing of special category data, including health data, under Article 9 of the GDPR, and identify which of the derogations under that article they intend to rely on for the purposes of the sharing.